Next case that we will hear this morning is case number 28604 and 28617, State of Ohio versus Andre Yeager. Attorney Agarwal is present for the appellant, Mr. Yeager. State of Ohio is not represented here today, so you will have 15 minutes. And of course, we've read the briefs, and we are prepared to proceed when you are.
Thank you, Your Honor. May it please the Court, Neil Agarwal for the appellant Andre Yeager. Your Honor, after I filed my brief and the state filed its brief, my client submitted his own brief to this court, basically saying all the ways I screwed up, and he wants he wanted to represent himself on appeal, or at least file his own brief to make his arguments. Nothing too unusual about that. However, the reason I'm bringing that story up is this court issued a journal entry afterwards, basically saying the defendant has no right to submit his own brief once he has appellate counsel acting as his attorney in his behalf. It is hybrid representation, and that is not permitted under Ohio law. And this court, throughout his brief, say we will not consider it, it's not added, so we're going to throw that out. That is exactly my argument in this case as part of the underlying case in the trial, and this is my second assignment of error, if I can get to that first. My client filed his own motion with the trial court in both cases saying, I'd like to represent myself. First of all, I would note a motion requesting to represent yourself, it is not a waiver of counsel, it is not a waiver as contemplated under Criminal Rule 44. The state says, well, once you file your motion, that is a written waiver. That is not. It is a request to the court of permission to allow you to represent yourself before you know all the ramifications, before you had the colloquy with the trial court, without any of that. So first of all, there is no written waiver as specifically required by the Ohio Supreme Court and the rule that there must be a written waiver of your right to counsel. That was never done. However, in any case, the trial court allowed the trial attorney to withdraw, allowed Mr. Yeager to represent himself, and I'll get that to my first assignment, but the trial court then appointed prior to trial an attorney to be standby counsel for Mr. Yeager. When we had the trial attorney allowed the standby counsel to participate fully throughout the proceeding as Mr. Yeager's attorney to the extent that Mr. Yeager wanted. And he specifically told the jury that the standby counsel, Mr. Perry, Joe Perry, he will be able to participate as much as he wants. He can do as little as he wants or as much as he wants. Strangely, nobody objected to that. The state didn't object to it. The defendant obviously didn't object to it. Mr. Perry didn't think he didn't object to it. And, the trial judge encouraged it, or at least told everyone he can participate as much or as little. Now, on page 11 of my brief, I listed all the different ways that Mr. Perry participated throughout the trial, even though he was only standby counsel. He did pretrial motions and proceedings with the defendant. He engaged in voir dire, Batson objections. He specifically made a Rule 29 motion on behalf of Mr. Yeager and then renewed the motion. At the time of the resting of the defendant's case, he made that argument. He made closing arguments with Mr. Yeager and the state. So Mr. Yeager got up, gave his closing argument, and then Mr. Perry gave up and also gave a closing argument as standby counsel. Okay? Then there was questions during the jury deliberations. Mr. Perry answered it on behalf of his client. Jury deliberation questions. That was also done by both Mr. Yeager and Mr. Perry. Arguments for sentencing were done by both Mr. Yeager and Attorney Perry.
Counsel, can you speak to whether or not, first, harmless error, and second, plain error with respect to this occurring at the trial court level without a contemporaneous objection by Mr. Yeager to the hybrid representation?
It is a fundamental violation of due process and my client's right to Sixth Amendment, Your Honor, when, and there is the Ohio Supreme Court directly on point called State versus Martin. And there they specifically says Ohio law does not allow hybrid representation in any way, shape, or form. It does not exist as a matter of law. We don't engage in it. We don't do it. It doesn't happen. So it is it's a plain error right off the bat that the trial court allowed it to happen and told the jury. And the state in its response, and they only wrote one page in my whole argument to this, is basically saying, so what? We're not disputing there was hybrid representation throughout this case or it was in violation of law. We're just saying basically big deal. The defendant got more than he was entitled to. He was able to participate in his own trial, and for whatever reason, Mr. Perry was able to assist him. So really, there was like kind of two attorneys throughout the trial. So, you know, you should be happy that that even happened. However, as the Ohio Supreme Court has held, there can be only one master in that case. Either it's the defendant or it's his attorney. You cannot have a difference between the attorney and his client and the representation. Who controls that case? You're both competing for the jury. You're both making arguments. And I even gave an example where the judge asked Mr. Perry and Mr. Yeager, do you want this evidence to be shown before the jury? The defendant says no. And Mr. Perry says, yeah, no objection. So that is the inherent problem with hybrid representation.
So in Ohio, an attorney is permitted to sit at a counsel table, answer questions for the defendant, one-on-one with the defendant, I'm talking about advise the defendant.
Absolutely, and that is his only role.
Okay, now what happens when the defendant changes his mind and asks counsel to participate?
Well, if that would have, that didn't happen, but let's say that does happen.
No, that didn't happen here.
We do know that, that it was hybrid, well, you didn't need to because he was able to participate throughout.
Okay.
So you didn't need him to say, well, you know what, I'm going to withdraw my pro se and allow him to take over.
What happens in the scenario I gave you?
Well, I would believe in that it's either too little, too late. It depends on really the trial judge. If all parties would waive him taking over at that point, I think that'd be fine. I think you could even declare a mistrial if it was the defendant's request and there's no prejudice. I mean, there's any number of options that could happen. You could just continue on at that point and have Mr. Perry just take over at that point.
Okay.
But in any case, this was a very strange trial as I was reading the transcript because Mr. Perry was doing everything and anything a trial attorney would along with the defendant. None of that is permissible under Ohio law. But even before we get to that course, the first one is what is required to even allow Mr. Yeager to withdraw his constitutional right to an attorney. Now, the Ohio Supreme Court and appellate law that I've cited throughout, it is a very specific right, but having an attorney is a fundamental constitutional right. It is the foundation of 200 years of jurisprudence. So in order to waive it, which of course the defendant has to do, the trial court has to go through a litany of a colloquy of all the rights and obligations to waive your right to an attorney. Do you understand trial procedures? Do you understand what it means to subpoena a witness, pretrial motions, motion to eliminate, opening arguments, closing arguments? Do you understand all that? None of that was done.
This case is sort of unique, isn't it, that Mr. Yeager has a history of representing himself and trying cases himself.
Yeah, you know, that was an interesting argument the state made, because when I looked at their evidence for that, I couldn't find it. They cited some appellate case that he's on, but I don't know if that's the same Andre Yeager as in this case. There was no evidence of that during the trial. It never brought out, oh, he had a prior appeal. Just because somebody has the same name as, you know, John Smith, and there was a prior appeal from John Smith, I don't know if this is that same gentleman or not. And of course, there's no trial transcript to say this guy's the same guy in the past. Then they say, well, he has prior criminal history. Well, that's true, but I don't know, and there was no transcript of the evidence of this docket shows he represented himself, or this. None of that was, it was all just gave to by the prosecutor in closing argument as to why you should sentence him.
Do you think the record reflects confusion on his part, or
Whose
on the part of Mr. Yeager? When
No, he clearly wanted to represent himself. He was very adamant about wanting to represent himself.
Are you suggesting that the colloquy between Mr. Yeager and the judge at that time was insufficient?
I am, Your Honor. That is,
And are you suggesting that, it almost sounds like you're telling me there's a specific script that the trial court has to stand by?
no, and I've cited case law that says there's not a specific A, B, C, D, but there are factors that you have to consider that the trial court has to go over to make it a knowingly, intelligent, and voluntary waiver. One, did you explain the maximum potential sentence? The trial judge did do that in this case, by the way. I'm not disputing that. But another one is, did you discuss trial procedure with him? That was never done. Did you tell him you'd be treated like a, held to the same standard as any defendant, as any attorney? That was not done. I mean, there are things that the judge did do, and the things the judge did not do. For example, never discussed with them trial procedures, the possible defenses to the charges. Are you claiming self-defense? Are you claiming it wasn't you? Are you claiming that you were somewhere else at the time of the offense?
Is it the judge's obligation to tell him the possible defenses, or just tell him there could be possible defenses that you may not be aware of?
Yeah, I'm sorry, that'd be true, but I'm saying that wasn't discussed either. There's nothing about potential defenses to the charges. The circumstances for mitigation, that was never done. Basically, the court has to look at it as, this court has to look at it as, did the defendant make a knowingly, intelligent, voluntary waiver of his rights with his eyes wide open as to what he was doing? Did he have a broad understanding of the whole matter? That is the exact language. I don't care that Mr. Yeager wanted to represent himself. That's fine, except before the judge would say, yeah, you can represent himself, you have to explain to him the possible advantages, well, I don't think there are very many advantages, but at least all of the disadvantages, the fool of representing yourself. And here the trial just said, you want to represent yourself? Okay, here are the maximum penalties, are you sure you want to do it? And he goes, yes, okay, that's fine. So I'm going to allow you to represent yourself, and that's the basic of it. And then during the trial, it was like, oh, well, here's your standby counsel, and he can do as much as you want to do throughout the trial. So those are my two first assignment of errors. Moving on, there was a restitution hearing. And during the restitution hearing, the prosecutor says, well, we're asking for X amount. Here are a bunch of documents that we show that shows defendant owes these thousands of dollars. And Mr. Yeager, again, pro se, says, I object. There's no witness here to testify these documents. I don't know what these documents are. I have no way of cross-examining these documents. I have no way to, defend these documents. And the state, in this brief, concedes this is an assignment of error. That's true. The trial judge just allowed a bunch of evidence to be brought in that wasn't cross-examined and testified.
That's not the point the state concedes on, though, is it?
Well, with the point they concede, well, they don't dispute that that's what happened, but the legal argument that they're conceding is the trial judge never considered my client's ability to pay. And the statute specifically requires there must be an ability to pay. Now, and they actually say, reverse and remand for a new sentencing hearing. So I think we're all in agreement on that. The next one is credits for time served. During the trial, during the sentencing, the trial says, I'm going to give you X amount of jail time credit. And my client says, well, I want all jail time credit from this earlier date, October something. And the trial judge says, basically, we will calculate it and just include it in your journal entry. The trial judge did not include the full amount of the jail time credit that he believed he was entitled to, did not give him that amount, nor did it schedule a hearing for that.
So what was the one requested?
Well, not in those words, Your Honor, but what I'm saying is when he's saying in a pro se manner, I want credit from this earlier date, at that point, the trial judge should have either given him that credit or held a hearing because there was a dispute at that point. And again, we're talking about a pro se, and I know he's held to the same standards, but there's also language that says you have to give a little bit of leeway on a pro se defendant as well. So I'm arguing the trial judge did not give him his credit that he believes he was entitled to. Now finally, court costs. In the transcripts, the trial court did not mention court costs, and at one point even mentioned we're waiving court costs. I'm arguing, under State versus Joseph by the Ohio Supreme Court, you have to say I'm putting court costs so he can request a waiver of those court costs. He was indigent. He did There wasn't, I believe, an affidavit filed in a timely manner, and I don't think the court did properly impose court costs. So with that, Your Honor, I ask the court to reverse the remand for a new trial. I'll listen.
Questions? All right, thank you very much, Mr. Ray.
Thank you, Your Honor.